First, let me thank the organizers for this opportunity and the wonderful hospitality. Warm greetings to all of you attending in person and online. I'm Marco and I'm with Stefania, Carlo and Maurizio, and we are the IACO project. Our project started from a competitive research grant provided at the height of the pandemic by the Italian Ministry of University in order to address the legal challenges raised by COVID-19. In April 2021, the project passed a first selection phase that led to the creation of the prototype described in the paper submitted to this conference. The results of this first step of the research are now under evaluation for a possible admission to the second part of the funding. Pardon. Okay. IACO final aim is to create a system of equitable algorithms based on AI to facilitate the redetermination of the rents of commercial lease contracts and to ensure the conservation of these contracts, whose balance has been deeply affected by the health emergency. We restrict to commercial lease contracts because this was one of the main topics of the jurisprudential debate that emerged in Italy in the aftermath of the pandemic. In fact, the lockdown type containment measures have limited several business activities, such as gyms, pools, other sports facilities, stores, and so on, and put tenants in difficulty in paying the rents. In this situation, many owners reacted asking for the termination of contract for breach. Anyway, many Italian judges have decided to reduce the amount of the rent, despite the Italian Civil Code, in case of contingencies, does not specifically provide remedies to renegotiate the contract, but only to cancel the contractual relationship. This happened according to a part of Italian legal doctrine that admitted a duty to renegotiate for the parties, deriving it from the general clause of good faith and from the constitutional principles and values of proportionality and social solidarity. Indeed, this duty already exists in other similar legal systems, such as the German and the French ones. Also in the international context, see the blue box. The discipline settled for cross-border contracts prefer maintenance remedies, suggesting, for example, the use of hardship clauses, which commit the parties to renegotiate the contract to face contingencies. In particular, the research team is made by a law unit, me and Stefania in this case, and the AI unit, Maurizio and Carlo, and combining different skills and expertise. In our vision, the IACO framework, thanks to NLP, should take the defense deed of the parties as input and return as output a decision to be proposed by two judges or other legal professionals, together with explanations. However, to manage the high complexity of our tax, we decided to postpone the implementation of the NLP phase and to train the prediction model using artificial generated defense deeds that were submitted to real judges, I mean professional judges, Italian judges, for labeling. And so I leave the word to Maurizio for the rest of the explanation. Thank you.
Thank you, Marco. Thank you, everybody. My name is AI team, part of the AI team. So can we switch slide? Should I do it?
Yes.
Oh, technology. Very good. So this is an infographic. Just look at the top half part of the infographic, illustrating you the framework of our project, and I'm supposed to illustrate you what this infographic is for. Is this also a pointer? Yes. So as Marco pointed out, Ideally, the framework should take the defense deeds, put them, that are the PDF in the image, put them in a pre-processing machine, put the pre-processed text, extracted text in a big, huge, or small, we don't know, language model that should output relevant features that then they are chained to a predictive model, which is trained all together with a single loss to predict the judge decision. And in the meanwhile, to emit some explanations that can talk about as the reasoning the judges is using to output that decision. As a first part of the project, we just focus on the predictive part, that is the last half, the right half on the top half in this infographic, meaning we started with a human-in-the-loop approach, meaning we talked together, the AI team and the law team, and we asked in particular the law team, which are, in your opinion, the features that are used by a judge in such a simple case? I point out we are restricting, we're narrowing our study is a use case, very, very simple, the simplest I could imagine, 2 parties and 1 simple decision, and reasoning reduced to feature importance. And we settled for 25 plausible features, and then we generated 1,000, let's say, vectors in dimension 25, using a technical language. We generated 1,000 defense deeds randomly using these 25 features. And then we assigned these defense deeds to real judges that are in the social circle of our law unit. These judges were asked just to give us a number. Will you give the reduction? If yes, how much will you give as a reduction? 0%, 5%, 10%? This was the categories. And almost 600 of them answered, meaning that we built a data set of 600 data points labeled that we used to train very simple model. Of course, with so few data points in the training set, we tried also with the neural network, but no need to use a very powerful model. We just use a random forest that worked, let's say, very well. I would say at a certain accuracy, but since we know that accuracy doesn't matter, it's not important, I don't remember the accuracy actually. And the model seemed to work. I point out in this very toy problem, let's say, 600 data points, but the nice part, I think, in this model is not the upper part of this infographic, but the lowest part, which are the explanation. We tried to extract with explainability techniques which of the features were most relevant for the judge to give that kind of decision. And this is the right moment to introduce you to our explainability guy. Meet Carlo, the explainer, which will explain you the explanation of our framework. Just this. See. The next one.
Next one.
Next one.
Okay, perfect. Can you hear me? Yes. Okay, now we are talking about explainable artificial intelligence. The main goal here is to offer to the judges or law practitioners or experts a set of tools and technique is able to better understand for the judges, of course, the outcome of the predictive model. Not just understand, but also challenge and contest the outcome of a predictive model. Here, I listed two different approach among all dozens explainability technique they are out of there. I choose two different approach. We think that these two are the two of the most valuable and relevant in our use case. The first one is called SHOP. Probably many of you already know about it. SHOP is a feature importance extractor. This means that SHOP gives you, tells you how each feature is important as a predictor of the final outcome. Here on the screen, I think you can read the 10, I think, or top 8 feature in our use case. The other algorithm is what is called a counterfactual extractor or counterfactual generator, which is a counterfactual instance. Given an instance, a counterfactual is another instance, different from the previous one, with a different outcome. This is a very broad definition, but usually one would like to look for counterfactuals that satisfy a set of rules and minimality condition. So basically, a counterfactual is very informative, is satisfy minimality property, and that it doesn't change so much between the counterfactual and the original instances. For this, we use Fat Forensics. There is an open source library. You can find it online. There are many tools at your disposal. One of these is a counterfactual generator. And this is particularly important to challenge and contest the model prediction. So the final part, the validation survey, after the second step of the review process, the peer review process, it became apparent that there was one big missing point in our first version of the paper. It was the absence of a validation with law experts, with judges and other law experts. So we designed a validation survey. This is basically an interview with 4 different class of people, judges, lawyers, law professors, and PhD and law students. And the validation survey, the structure you see in 3 different set of questions. Basically, we start the interview offering them synthetic defense bid and ask them to what extent they agree or disagree with the prediction of the model. If they are satisfied with the amount of quantity and quality of the information in the document, and to what extent they think the synthetic defense bid resembles a real document, a real defense bid. The other 2 layers of question are related to the 2 algorithms I show in the upper part. So we offer them the 3 most important feature according to the SHOP algorithm, of course, and ask them if they agree or not to this categorization, to these importance values. And also we present them 3 different counterfactuals. And here we are looking also for to measure the trust and confidence towards the artificial intelligence models before and after looking at the explanation given by counterfactual generator and the feature importance extractor. The validation is still ongoing. Okay, I'm closing. The validation is still ongoing, and the final statistic will be published in the final version of the paper. We already collected 120 interviews. There are a lot, so we are very positive about this validation survey. And now I'll give you the floor to Stefania, who will conclude with the last part.
Okay. As you can imagine, our system, the model described by Marco, Carlo, and Maurizio, has several impacts also on the judicial system. In particular, this framework could guarantee greater uniformity of the judgment and legal certainty, because it gives to the judge a tool, a benchmark to compare his decision. A similar system is already used in Italy for the quantification of the compensation of non-pecuniary damage. And the reference is to Tabelle di Milano, elaborated by the Observatory of the Court of Milan and used in the entire Italian national territory. These tables, however, are not mandatory for judges, so they can always, and maybe in that case must, customize the decision proposed. And so the discretion of the judge is not eliminated. Also in our case, in the IACO system, starting from the suggestion of the algorithm, the judge would compensate for any bias or other possible limitation of the system, and in a corrective way. Also the human decision, we know that is affected by bias, so in our perspective, the man-human integration could overcome both human and artificial limits. In addition, this system can potentially facilitate the access to justice and ensure the effective protection of human rights during the trial. And so, in particular, because this system may affect the duration of the trial, speeding up decision. In this way, the judge is facilitated in his decision, and so also in harmony with the principle of fair trial and the reasonable length of the trial granted by Article 6 of European Charter of Fundamental Rights and also Italian Constitution. On the other hand, in the no-litigation phase, IACO acts as a tool to decrease the number of the cases litigated before the courts. And in our perspective, this system does not change the appel system. So also this decision can be contested with the ordinary way. This predictive framework, in our perspective, has wide potential because it can be extended to other civil issues. So, for example, those relating to family law, inheritance law, or executive and insolvency procedures. However, despite the mentioned wide potential of this project, the old research project does not question the irreplaceable nature of the judge natural person. So also in the use of the AI systems. The decision must still be judge-centric and so subject to human control as required also by the human-centric approach that inspires the European strategy on AI. So we don't want to replace judge, but we think that it's important the man-machine integration that cannot be ignored in order to achieve fair justice. And thanks.
4 people speaking in 15 minutes. Huh? That's very impressive, if not incredible. Thank you very much. The replier can take the floor. Caroline Cauffman.
Yeah, good. So first of all, I would like to thank the organizers for inviting me to comment on this very fascinating paper. And I really agree that it is a good approach to use AI as a tool to assist citizens to solve their issues in the pre-litigation stage and to assist judges in the litigation stage. Without compromising the right of a citizen to have its case heard by a human judge who is not bound by the solution produced by a machine. I also agree that the use of the system is likely to lead to a more equal treatment of similar cases, irrespective of the specific judge who is hearing the case. in case you would still have time to amend the paper, I would advise to focus on the methodological part and to clarify the methodological part. It may all be very clear to computer scientists, but to lawyers, or I cannot speak for all lawyers, in any case, to me, it wasn't entirely clear, and it left me with quite some questions. A third part of my questions and comments relates to the current model that is based on the informational features that you have selected, and may be solved once that NLP stage has produced results. The second set of questions and comments is a bit more serious and might continue to remain even after the NLP stage. Relating to the part that was discussed in this particular paper, the first stage of the project, I noticed that you wrote that you started with an expert-based selection of the most informative features identified in 25 fields, but there it wasn't clear to me who were these experts. Were those the lawyers in the team, or the judges, or still other experts? And it wasn't clear how they selected the 25 informative features based on existing cases, on similar cases, on what they just would take into account themselves. And then when I looked into the list, the graphs with the 25 informative features, I didn't really understand what was meant by the monthly deposits. It cannot refer to the monthly rent because that was a separate feature. And what I know as a deposit in rental contracts is generally a lump sum that is paid at the start of the contract. So that is not monthly. So I didn't know what it was. It might be something particular in Italian law, but I already consulted an Italian colleague who is probably following the conference online, but he couldn't give meaning to this either. And then it was written that when the nature of the owner is natural person, then the quality of the owner is private. I didn't really get it either. When a natural person rents out things in the performance of his profession as a professional activity, he carries out a commercial activity, and then he is not acting as a private person. So what does private mean as quality? So these were my main comments with regard to this first stage of the project. The second set of questions and comments relates to the separation between the two stages, and the fact that it is argued that the NLP feature extraction is left to a later stage because it would be very expensive in terms of time and resources. And then, yes, intuitively, I think that is likely to be true, but did the researchers also rely on intuition for this statement, or did you carry out any experiments that supported this statement? That is not clarified in the paper, and I'm curious. And I also wondered whether this difficulty of the NLP feature extraction is related to the fact that you plan to use defense deeds, because these are generally not published. Again, not sure about Italy, but in most legal systems, these are not published. What you find in the decision is only the judge's summary, which may entirely reflect the content of the defense deed, but is also in a way already an interpretation. And to which extent could this problem, if the problem is access to the defense deeds, could this be solved by using the summary given by the judge? Or to which extent would using the summary given by the judge affect the quality of the system? And then if this NLP stage will be so time-consuming and the system is intended to deal with a very specific problem, the requests for a reduction of the rent by people whose income was reduced as a result of the lockdowns, which occurred in a very specific period of time that is already in the past, how timely will your product then be? Will these cases not be decided manually by the time that the model is ready? But I recognize that this is a very practical issue, and it does not affect the academic value of the exercise, and that value will definitely persist if the model can be easily transferred to other legal issues. So I'm looking forward to your reply.
Thank you very much. The floor is now back to
Thank you.
the team.
Yes, I try to answer to Caroline. Thank you. Your feedback are very useful, and so thanks for the reply, the suggestions, and the time that you spent on reading our project. I don't know if I catch all the questions, so help me if I don't, because I read the maximum of the university. Now it's time of tenebras, the darkness, so in Latin, but science will help me. About the features, we extract them from real decisions, because at the beginning we have judges that took decisions on these issues, but we don't have time to wait the others, because this kind of jurisprudential debate started in 2020, and also now we continue to have new decisions about these issues, but we have to close our project and our research first. We can wait, and so we decided to artificially generate the decision. And
Sorry, Marco.
Yes.
So we are answering, just to clarify, we're answering the first question, which is who are the experts that selected the features, the 25 features, and how they were selected. So the experts, is you, Stefania, and
yes, or the selection,
and the
yes.
other.
Yes, we selected the features starting from real decisions, and we asked to real judges to validate these features, because we are lucky. These cases are very simple, and the decisions are very standardized. So the likely cases we generated with these 25 features summarizes the defense deeds and have always the same structure. So, for example, I took note of what you said before. We have Dude, Marco Rossi in Italian, a private person. That means if it is a business, this is a private business. A private person means that Marco Rossi isn't an authority or a public person, and he conducts he runs a business like a private person. And then I took note about the maybe I think you want to refer to the guarantee, and this is one of the relevant features, because when judges take a decision, they consider if the the tenant, sorry, left or give him a guarantee. And so we decided to consider this feature in the panel, in the 25 features we considered. But also
Like the
deposit. Okay, thank you very much. And the same consideration, the same reason, for the same reason, we consider tax credit and also a possible government aid that the authority give rental to support the income, their income, and also the income of the owner and the income of the tenant was considered like a relevant feature. And I don't know if my tenebras, my darkness in this point took the advantage on myself, and also I don't know if I
If you answered.
yes all the question, maybe not. Stefania, if you want to add something.
Can I start? You were asking something about the constraints also. Did you answer about the constraints?
No,
something
no.
about private, not private.
No, not this, not because why it is private and
Can you answer quickly?
yes, I explain why private is not public and not an authority, and when the tenant is a private person, not a legal person, but
exactly. So you were talking about a natural person.
natural person, thank you, it can be public. So this is the constraint that we consider in creating the features.
Yeah, the nature of the owner is natural or legal person, and the quality of the owner
Public
is
or private.
Public or private. Yeah.
Will you remember this terminology for the next version
Yes,
of the
yes.
paper? Okay. I already forgot. Just to clarify, these constraints, I guess it's clear for you, but for the audience, these constraints were imposed on feature generation to obtain a random generation of likely to happen cases. I mean, to not obtain somebody which is a salary income of 0 and is owning a building and so on. Okay, so this ends the first type of questions on the model. And then, yes, there are the NLP. So why is NLP expensive in terms of times and resources? We didn't quantify it, but training by NLP, we mean these huge, very large, very big models with billions, if not trillions of parameters. So in order to train them from scratch, you need, of course, a lot of resources from the computational point of view. Of course, we could argue whether we need such a big computational power in this approach. That depends on the amount of training data we have, and we will say something about this later.
Later is that we still have 3 minutes.
Oh,
And
yes.
I'd also like to take some questions.
Okay. Okay, we didn't quantify it, but we plan to use a pre-trained model, BERT, which is in a version which is legalized already for legal terms, so could be not really very expensive in this sense. Regarding the other part, that defense deeds are not public usually. Actually, there is a good news thanks to the money of Europe or the PNRR. In Italy, we are planning something that I'm not able to explain.
Yes.
So she will
Because in
explain.
Italy we have the telematic process. So all the defense deeds and the decision of the judges are are in a cloud system in possession of the Italian Minister of Justice.
Not public for the
Not
moment.
public for the moment, but with the Italian National Plan of Resilience, this plan aims to digitize about 11 million of court documents. So in the future, this system could be implemented in this way.
Final question: isn't this product already not updated? The opposite of updated. Already outdated because COVID is hopefully no more with us. Yes, but as Stefania said, mentioned in the conclusion, this is a use case that can easily extend it to other use cases. That means contracts between two parties with a simple decision, which is numerical. I mean, we can think about several use cases in this respect.
Yes, so I have other questions that we put there offline, but I start from this one, I start the center because what we're doing here is a kind of,
So my question would be, what you're doing here, it's a kind of induction process. So you're looking at the individual decision that the judges are doing against scenarios that you're creating. Then you're trying to understand what is their boundary decision. I mean, it depends of the output, but in any case, you're recreating the implicit rule that all these judges are applying, and then you're automatizing that. So obviously, these capture a way in which the judges are reasoning into that specific time, or I mean, it's very much contextualized in the moment in which you have captured that from the judge. Then you are reified into an artifact, but then you don't know whether the context is going to be changed in another point. So what are, again, the structure that you have around this process in order to deal, I don't know, with a decay effect? I don't know how to call it, in the sense that at a certain point, this model will deteriorate. So what are the processes in place to check whether that's the case, and how to deal with that?
Yeah. Okay, you are saying that we are not capturing the dynamics of the process. Yes, that's true. If we want to capture, we have to retrain the model if it works. But we start, let's check if it works in a frozen time.
No, I agree. But the point is that if you're already thinking how to do that, to understand when it's not anymore valid what you have constructed in that moment in time.
Well, for the moment, I'm more interested in whether this will work or not, because if it is not clear, this is a use case. The simplest use case we can think that we can use to support or refute the hypothesis that NLP can be used to support judges in decision. If we can't have help in this very simple decision, then the answer is no.
I recognize what you're saying. This is more the technical problem of building a tool, but what I'm asking rather is, what are your expectations when you're doing such a process? I mean, how long it will last? How fast it is going to be degraded? So, I mean, what type of protection? You're saying, okay, we can set up this process, but you need to consider that after 1 year, you need to redo it or to test it whether it's still good. I mean, this kind
Honestly,
of meta process.
We completely didn't think about this, but now that you're mentioning, it's a very good suggestion. We could,
wow.
I mean, as soon as we have some evidence that this is working, we can think about models which are dynamic in some way. If we use transformer, we can use temporal fusion transformer. We can use temporal graph neural networks something like this, but that overshooting, of course.
Okay, so this is a really important question. So imagine if you are updating while the new court cases come in, if you can build a system that can do that, there is nothing that shows better that we're then going to have input into the court decisions that is the output of the past court decisions. So that's what I mean when I say scaling the past and freezing the future. So you're basically then feeding new cases with the output of what is built on old cases. And there is a loop here. There's a dynamic that is highly problematic. And I'm not saying it's wrong, but it comes out beautifully because you can see it like running in front of your face. It's, once again, the output of prior decisions is going to, which is automated, is the input into future decisions, and then there is a totally new dynamics. And I see a question there, and actually Arjun was first, so. And then now we are in blessuretijd, hè? So that's a Dutch football term, sorry.
Thank you guys so much
Please.
for the presentation. We had a small discussion about this yesterday as well, and Caroline articulated my questions that I had yesterday very well. So thank you for the amazing feedback. In the slide, impact to justice, you say that this system will overcome both the human and the artificial limits, proposing decision as fair as possible. This is a very big claim made in simple words. So impact to justice, yeah. So this is a very big claim made in simple words. So we can get into more philosophical questions. What is fair? Or you can explain how do you substantiate this claim? Thank you.
We know that
Just a small question, right?
there are a lot of questions, and we know that our system cannot resolve all the legal issues raised by the use of the AI. We think that, for example, as Holmes points out, legal certainty is never given, also by the human decision. So we think that for this reason, the human decision is not always fair. The AI decision is not always fair because we know that AI has a lot of bias and is a black box, and all the problems that we know are related to the use of AI. So we think that if we continue to study the integration of man-machine system, we can maybe in the future have some results also in this way.
Let's end on this very positive note. I've seen there are more questions, but we can take them to the coffee. Okay. Thank you very much.
Thank you.